Like most civil lawsuits that are pending on appeal, while you're waiting for the decision, you just accept the fact that you have no idea when it's going to happen, and when it does, it will feel like a lightning bolt. The lightning bolt arrived yesterday for Jon Gruden, the former Raiders coach who had sued the NFL and Commissioner Roger Goodell after he was forced to resign following the deliberate leak to multiple media outlets of emails that he had sent in 2011 while employed by ESPN, not by any NFL team, from a supposedly confidential Washington investigation. They were weaponized to get him to go. And setting aside whether or not the emails were appropriate, the question is whether or not someone violated his rights by taking those emails and getting him out of his job with the Raiders. He sued the league, he sued the commissioner, and the question had lingered since November of 2021, will he be required to go to arbitration, or will he be able to go to open court and litigate with filings that we can see, proceedings that reporters can attend, a trial that will eventually happen out in the open and not in a conference room somewhere tucked away from anyone who would monitor and report back to the rest of the world what transpired. A key thing for the NFL. And we know this. The NFL always wants to arbitrate. Secret rigged kangaroo court of arbitration, as I call it from time to time, because not only do they try to arbitrate with an outside entity who isn't a jury, they try to arbitrate with the commissioner ultimately responsible for the arbitration. So that was the fight. Round one went to Jon Gruden. The trial court found that the arbitration clause that the NFL was trying to enforce, specifically an arbitration clause contained in the NFL Constitution and bylaws, did not apply to Jon Gruden. NFL appealed, went to the Nevada Supreme Court. And the way it works, 3 judges randomly assigned to every case that goes to the Nevada Supreme Court. 2 of the 3 found that the arbitration clause in the NFL Constitution and bylaws should be enforced. So, Gruden was going to have to go to arbitration, but he had one trick left. One opportunity remained. He filed what's called a motion for a rehearing before the entire Nevada Supreme Court. Those things don't succeed very often. Just getting the rehearing. He got the rehearing before the 7-judge court. And we waited. People would ask me from time to time, what's up with Jon Gruden's case? We're waiting. And we waited some more. And yesterday, 5-2 ruling, the Nevada Supreme Court found that Jon Gruden does not have to submit his claims to arbitration. That it's unconscionable to have an arbitration clause where, in a case like this, the commissioner is responsible for the arbitration of a claim against the commissioner. So now we go back to the trial court level in Nevada, and we commence the litigation. There's a caveat there, an asterisk. The NFL undoubtedly will file a petition for appeal with the U.S. Supreme Court. I've asked the NFL for comment, sent a couple of emails. Basically, the message was, if we have something, we'll let you know. Well, they'll have a deadline to file their petition with the U.S. Supreme Court. They did it when they were sued by various St. Louis entities after the Rams moved to L.A. There was an arbitration clause that the NFL was trying to enforce some way, somehow, and they took that all the way to the U.S. Supreme Court. So I think they'll try to take it to the U.S. Supreme Court. The first question is, will the Supreme Court take it? The second question is, if they take it, will they fine for the NFL or will they fine for Jon Gruden? And this is where it gets very interesting politically, okay? Because the current constitution of the U.S. Supreme Court suggests that in a case like this, the ideology of the judges, and this is not a political statement, this is a political observation, the ideologies of the judges would skew toward fining for the NFL and finding that arbitration is required. But you've got a couple of factors here. You got a couple of factors. Number one, Jon Gruden is a pretty staunch conservative. He has that working in his favor, especially if that has allowed him to be in the good graces of the commander-in-chief. Oh, and the commander-in-chief isn't a big fan of the NFL. Now, look, I doubt that there would be any direct communications to the Supreme Court that maybe in this case we go against our pro-business mindset and fine for Jon Gruden, but it's it's an interesting dynamic because in the ordinary case of this nature, the current governmental apparatus would be more inclined to let the business have its way and arbitrate the case. In this case, there's enough reason to wonder, could it go the other way? Mainly because of the president's attitude toward the NFL. But we'll see. First, the NFL has to file the petition for appeal, and then the Supreme Court has to take it. And it could be that if they take it, they're more likely to find that the case should go to arbitration. And here's the risk, because I think it's been long overdue for someone to attack the ability of the commissioner to serve as the arbitrator in cases involving either him directly or the people who have hired him and who pay him, the members of the NFL. If the NFL would win, I'm concerned that all of the other companies out there that try to avoid being accountable in open court in front of a jury, that want to have a rigged system, not quite as rigged as the NFL, they'll rig it even more. Instead of appointing an arbitrator from the American Arbitration Association or some other arbitration body that kind of skews pro-business, just kind of the way they do. The whole process is favorable to business. When you have one person reaching the decision instead of a jury, there's wisdom in a jury. You know, in the collusion case the NFL dealt with, there was an arbitrator who I think just got it wrong, read the circumstantial evidence incorrectly, failed to call BS on the NFL's official position that it did not collude. When you have a jury, I think it's easier for that collective wisdom to take over. Well, if the NFL would win this case, you're going to have companies that decide to make the CEO the arbitrator, the CEO or his or her designee. So there's a lot at stake here. And let's fast forward to a point where Let's assume that the case is going to go back to court, that whatever the NFL may try to do with the Supreme Court fails, and Jon Gruden is allowed to pursue his claims against the league and the commissioner in open court in Nevada. The discovery process will begin, which means his lawyers will be able to start the effort to find out who it was that weaponized those emails. Not many people had access to those emails. Someone took those emails and initially gave some to the Wall Street Journal, which reported on certain aspects of what Gruden had said. Remember the things he said about DeMaurice Smith? That came out on a Friday with the goal, I believe, of getting him to step down. When he didn't, on Monday, more emails were leaked to the New York Times. That had the desired effect. At least that's going to be the theory. And why else would someone have leaked? Some to the Wall Street Journal, some to the New York Times. So we find out who ordered the code red. And I think it's important, as I've said before, somebody undermined the integrity of an entire football season by taking out the Raiders coach 5 weeks into the season. This information was known in June of 2021. He could have been fired then or pushed out then. They could have held it until after the season. It happened during the season. And for a sport that is so obsessed with integrity, they completely warped the integrity of the season by forcing one of the teams to change coaches over something that could have been handled before or after the season had concluded. Now, before we find out who ordered the code red, the NFL may throw a bunch of money at Jon Gruden to try to get him to settle the case. There was a report from ESPN a couple of years ago, a deep dive into the whole Gruden emails and associated issues. And in there, it was reported that Gruden wants to burn the house down through this litigation. That would suggest that whatever they offer him in settlement, he's going to say, no, I want to see this through. Easier said than done. Because once they start putting money on the table, as that money goes up and up and up, he may finally get an offer that he can't refuse. And the last wrinkle is this. I think he wants a coach again. Is there a way the NFL can play this where somebody makes a phone call or two, somebody ensures that someone gets hired to be a head coach again, and that takes the steam out of Jon Gruden's effort to burn the house down. The only problem is this. You need to be careful how much of it you articulate, because you can create a separate problem for yourself. If you start tying settlement to getting a guy hired, that will raise antitrust concerns, collusion concerns, and all sorts of problems for the league. So there is a graceful way this has to be done if the league would try to do it. But that may be the Hail Mary play that the league will try to counter the Hail Mary play that Gruden ran that won. The league's Hail Mary may be, let's find a way to get this guy back in the NFL, and maybe he'll take our settlement offer, and maybe the house won't be burned down. Regardless, we'll continue to monitor the case every step of the way. It's gotten very interesting because finally Gruden has that ticket to open court, and it's up to the NFL to try to take it away with a last gasp effort to the U.S. Supreme Court. And then if that fails, who knows what happens next. We'll continue to update the story at ProFootballTalk.com and right here at PFTPM as the case continues to develop. Have a great day. Hi, it's Mike Florio. Thanks for watching PFT on YouTube. Hit subscribe for the latest news and analysis from Pro Football Talk.